After a month of controversies on whether it's lawful for the IGP General Kale Kayihura to appear before the courts of law to answer instituted cases of torture against him as an individual, the beacons of the law in Uganda's temple of justice have been at crossroads on whether the hunter should be hunted. However, a fortnight ago, the Chief Justice broke the silence that the IGP should respect the law and appear before the courts of law to answer for the criminal summons of torture against him. However, in what now turned out to be the legal battle of the mind, Chief Justice Bart Katurebe's interpretation was found not binding on Uganda's statutory law books. But how did the Deputy Chief Justice Stephen Kavuma found it wanting to be narrowed to a mere administrative statement?
What the CJ said was an ordinary comment because he was not speaking as a court. The DCJ was speaking as a court. So the CJ was making what you would call a comment about what was going on in the judiciary. And that comment is not binding. It has no force of law. Whereas what the DCJ did has a force of law because his orders were issued as a court orders. So that's the difference. And there is no contradiction, therefore. If the CJ had issued a directive, if the matter were in the Supreme Court, then the DCJ will not issue that sort of order.
Chief Justice was justified to say, let each and every one appear before court. Now, when Kavuma comes up as the Deputy Chief Justice, he came out when matters were before him, before courts of law. Now, to that extent, Sibasi and viewers, we may have to look at what exactly the Deputy Chief Justice was deliberating. He is presiding over a matter that was being guided by the Chief Justice, but the way I saw it, it was an application. Some private individual came up with an application. And to be on the right side, I know let's look at this application, but the general guiding principle should be, it shouldn't be done to make the judicial proceedings useless.
Deputy Chief Justice Stephen Kavuma took advantage of the Constitutional Court premises to legally override the Chief Justice Katurebe's interpretation.
So the Constitutional Court is closed with powers to stay proceedings, any proceedings. If issues of constitutional interpretation are before it, it is absolutely normal and there is nothing irregular about it. However, if any party is dissatisfied with that stay, then it can lodge an application within the Constitutional Court to have that interim order reversed. But really, it is normal, it's provided for under the law, and it is a practice. What is important is any party dissatisfied can go to the same court and apply for a remedy.
Particularly, why Justice Kavuma came up with that holding. I've not read through the ingredients, but the general principle should be, if he's saying that his temporary stay is awaiting the main application, let that application be put before court, and it is determined whether General Kayihura can appear in court or not. I want to uphold the constitutional governance of the country, and I know at a given point in time, let it not be the usual way Kavuma does it. Because usually he says until the main application is heard and disposed of, which may never take place. But this time round, let that main application be heard by the quorum of justices, the 5 of them, then we get to know what comes out of it.
Any order issued by Justice Kavuma is a lawful order. I'm talking as an advocate. It is a lawful order. So any lawyer should look for where to challenge that order. So Justice Kavuma's stay is just saying, hold on with the criminal prosecution of Kayihura until the constitutional matter is determined. That is very normal practice. I don't think it is right for any Ugandan to start taking it bad against Justice Kavuma. People made an application before him. He issued an order for stay of prosecution of IGP until the matter in Constitutional Court is determined. And the matter in Constitutional Court is very rich for democracy in Uganda, because we want to determine whether the Inspector General of Police, who has been acting in his capacity as Inspector General of Police, can be charged individually for crimes committed. So this issue has to be determined by the Constitutional Court.
Justice Kavuma's ruling has also labeled the move by the DPP to investigate the IGP meaningless, as well as null and void.
The DPP's action has been overtaken by events, because the Constitutional Court decision supersedes, and it is binding also on the DPP. So really, the DPP's action of taking over has been superseded by events.
All this, to me, at the face of it, I would say there is already a problem in the Constitution. Because at which point does the DPP take over a case? To me, my interpretation is the DPP takes over a case once it has been instituted. Once someone has appeared in court and taken plea. So Kayihura has not appeared in court and taken plea. So there is no way you can take over a case which we are just imagining. Like if I'm imagining to sue Besige, the DPP cannot say he wants to take over the case. So the DPP can take over a case that has started. So what should have happened was Kayihura to take plea, and then after the IGP taking plea, then the DPP can take over the case.
But what I'm saying is that it shouldn't be done to frustrate justice. In all criminal proceedings, and you've all been seeing it, whichever matters we've been having, the DPP has been taking over. But what I'm saying this time around is also to the good of General Kayihura once these matters are disposed of in a free environment of court. I know he will have his side of the story to be put. At some point, we shall all get to know. If he is wrongly implicated, then that's it. But according to me as a person, where General Kayihura has not only stopped at that impunity, but has gone ahead to institute the tribunal within police, he should follow up that matter to be concluded so that all groups can be winners.
The DPP is wrong on this matter. They are just for politics. The same thing when they basically brought a case against the state for maliciously prosecuting him for raping an individual. The DPP took over Besige's case, and they slept over it, and the case died up to today. So the spirit of Article 120 of the Constitution, that the DPP should take over a case to help in fast prosecution, because for me, I can institute criminal proceedings on someone. So what the law intended to do was that if a man from Kapchorwa he wants to prosecute a minister, he should not wait for the police and DPP. You can go to court and make a complaint under oath to the magistrate, and then you institute criminal proceedings. So the DPP can only take over to help people with the investigation to fasten the case. But the spirit in which the DPP is taking over cases in Uganda is in bad faith. It's just to take it and sleep over it and make sure the case dies.
But what implication does Justice Kavuma's ruling have on the state and the tempo of justice?
The state is at its weakest. They have resolved at a political level that it is not good for them to try Kayihura. It is not good for law and order for Kayihura to appear in court even once. So as a political scientist turned lawyer, I can say as day follows night, Kayihura will never appear in any court under Museveni's regime. So these things happening by the DPP, by the stay of execution by the Chief Justice is part of the master plan to save the face of the state. Because the state thinks if you try an IGP, then who is going to enforce law and order? So they have resolved at a political level. I can swear as day follows night, Kayihura will not appear before any courts of law. And in an event he has to appear, it would be to save the face of the government. But by that time they would have even determined with the judiciary what they should do when he appears.
There is an indication that that Justice Kavuma, the one I call Justice Kavuma, is acting contrary to what the Chief Judge is doing. Because if the Chief Justice says something and you say the opposite of it, that is an indication that you are parallel. You don't work together. You don't sit together when you're making such kind of judgments. So I'm not surprised. But of course, when, Judge Katurebe has been on record as a clean man somehow. But this one, just Injustice Stephen Kavuma, I call him Injustice Stephen Kavuma as a member of parliament, has been like that. And there are certain matters which need to, at least at a level where he is, there are certain matters where he is supposed to refrain from making some kind of judgments, which are even seen by a kid, that they should go the other way. But instead, he takes them to the opposite way where they aren't supposed to be. So I'm not surprised.
Timothy Sibasi, the Star Vision, Parliament.